Hello, and good morning, good afternoon, good evening, depending on where you are. My name is Alexandra Semira Gavrilonak, and as the Vice Chair of the Board of the European Network on Statelessness, shortly ENS, it is my pleasure to welcome you all to today's webinar, Identifying and Protecting Displaced Stateless People in Europe, What Needs to Happen Next. For those of you who may not be familiar with ENS, we are a civil society alliance of over 180 organizations and also individual experts working across 41 European countries to address statelessness through law and policy development, through awareness raising, and also capacity building. And we are really glad to see so many of you already joining us today. I think it's around 50 participants right now, and the number is increasing as we go on. You should now see a quick poll on your screen, which will help us better understand who is in the room. And if possible, we will make sure to tailor the discussion as much as possible to your knowledge and to your interests on the topic. As we continue and before we begin, just a couple of quick housekeeping points. You can use the chat or the Q&A function throughout the webinar to share comments or ask questions to our panelists. And our colleague Cameron will be monitoring these and will either respond directly in writing or flag these questions for our live Q&A segments. If we don't have enough time to respond to your questions, please do not hesitate to follow up with us after today's webinar. We would really be happy to be the start of a continued conversation on those questions. The aim of today's webinar is to bring together experts, practitioners, and advocates to reflect on where Europe currently stands when it comes to identifying and protecting stateless people. And most importantly, what further action is urgently needed. And we will begin with an overview from the ENS team on the progress and backslides across Europe on protection for stateless people, drawing on the latest updated index briefing on this topic. And after that, we will move to two exciting expert panel discussions. The first one focusing on national level practices and experiences in Germany, Portugal, and Austria. And second, looking at opportunities and risks at the regional level. And before we move on and before I hand over to the moderators of these panel discussions, I just wanted to very briefly underline why the conversation is so urgent now. Statelessness is often described as a legal issue, and of course it is a legal issue, but it is also something that shapes almost every aspect of a person's life. When states fail to protect and to properly identify statelessness, it can leave people in prolonged uncertainty, facing barriers to access very basic rights and navigating systems that were created and were simply not designed with their realities in mind. And when displacement is added to that, these challenges are compounded even further, and stateless people can fall then through multiple gaps at once in the asylum systems, in the migration procedures, and also in access to protection that should be granted. But these gaps are not inevitable. They are the results of systems that can and must be improved. And we know that more effective responses are possible when they are informed and designed collaboratively with those with lived experience of statelessness. So today is about identifying where those solutions already exist, where we need to go further, and how we can work in more coordinated and inclusive ways together with stateless communities to ensure that no one remains unprotected and invisible within the existing systems. So now I'm very pleased to introduce our first speaker, Patricia Cabral, a legal policy coordinator at ENS, who will walk us through the key findings of the latest thematic briefing on statelessness, determination, and protection in Europe. Patricia will be also moderating the first panel. So over to you, Patricia.
Thank you so much, Alexandra, and good morning, everyone. Thank you as well to Alexandra for such a brilliant initial introduction to the topic. I will start sharing my slides. It's the only time today that you will see slides, so please bear with me. I promise to try and not keep you too dry. But so just to bring us back to what we're doing here today, the webinar is focusing on identification and protection of stateless people. But before we talk about that, let's first talk about what is statelessness. Although Alexandra has already done very well the connection with statelessness and displacement, and also explained the impact of statelessness. And all of you here today, you actually have a lot of knowledge on statelessness according to the poll. So you already know that to be stateless is to not have a nationality. And as mentioned, without the protection of a state, stateless people are often denied rights that those of us who hold a passport very much take for granted. And so that's why we need to identify stateless people and grant the protection to prevent that they fall into a limbo and remain at risk of human rights violations. But an important thing to note first is that statelessness happens in two contexts. It happens first in a migration context or in connection to forced displacement, but it can also happen in situ. So essentially when several generations of in the same family have been affected by statelessness and have always lived in the same country or region. And the solutions to addressing each of these are different. What we will be talking about today is most important to address statelessness, particularly in the migratory context. And that's why we have added the word displaced to the title of this webinar. And having already focused on the challenges, as Alexandra mentioned, I want to talk about the solutions to address this. So what do we first need to protect stateless people in a migratory context? The first step is really having a legal framework in place that defines who is stateless and what rights people are entitled to. And the basis for this is the 1954 Convention relating to the status of stateless persons, which all EU member states except Cyprus, Estonia, and Poland are a party to. Then the second step is for states to identify who is stateless in their country, including by having information available about statelessness and making sure that competent authorities are trained and equipped to identify stateless people and then refer them to the next step. The next step is a dedicated procedure to officially determine statelessness, which in short we call SDP for Statelessness Determination Procedure. And this should be done in line with UNHCR guidance and other best practice that has been published by several organizations and by ENS as well. Then fourthly, when someone has been recognized as stateless, the procedure must lead to a protection status, which should include all the relevant economic and social rights established in the 1954 Convention, which I will cover later in my presentation as well. And what the 1954 Convention requires is that states not only implement a procedure, but really grant these rights. So even if a state has a procedure to determine statelessness, if it does not lead to this protection, the state will still be breaching its international obligations. And finally, statelessness is only ultimately resolved when the person has acquired a nationality. And therefore, the 1954 Convention also obliges states to put in place measures that facilitate the naturalization of stateless people. With this introduction of what it means to protect stateless people, we can now look at the overview of Europe, which is what I have been asked to do today. And the information I will be presenting is based on the Statelessness Index, which is essentially an online comparative tool, free to use, which you can access on the website, and my colleague Cameron will be sharing in a second on the chat as well. That is developed by and maintained by ENS in partnership with our country experts across Europe, and it assesses how the laws, policies, and practices of 35 European countries are performing in addressing statelessness. So this allows us to do a comparative analysis and identifying common challenges across Europe, but also the best practice examples from across the continent. The index itself has 5 different themes, but today we will be focusing on statelessness, determination, and status. And the results that I will be publishing are from a thematic briefing on stateless determination and protection in Europe, which we first published in 2021 with information from 27 countries. And now last October, we have published it again, an updated version, which now covers 34 countries and doesn't include Armenia, which has been added to the index last December. And it also includes information about the new procedures and changes that have happened over the last 4 years. So again, my colleague Cameron will share the link in the chat to the briefing, and you can see all the details about this analysis after the webinar. The first overview I want to take you to is through which countries across Europe have an SDP in place. Bear in mind that this map only focuses on countries that we cover in the Statelessness Index and not all of the European countries. But so out of these 35 countries, 19 have a specific procedure to determine statelessness. But in 6 of these countries, a determination of statelessness does not automatically lead to protection, or it only leads to limited rights. And so we don't consider them to be fully functioning SDPs, and those are marked in orange. All the others are marked in green. France, Georgia, and Moldova, for example, are among some of the countries that assess most positively in this theme because they have SDPs that lead to dedicated statelessness status and many procedural safeguards in place that are in line with best practice. Then some countries with SDPs are assessed less positively due to some shortcomings in the procedure, but they are still marked as green here on this map. In the orange category, you can see some countries that have a procedure that aims to determine statelessness, but it doesn't lead to dedicated statelessness status or to very limited rights. And so, for example, in Belgium and the Netherlands, there's both a judicial procedure through which statelessness can be determined, an administrative procedure where people can be granted a residence permit. But there are issues with how these procedures speak to each other, about eligibility requirements for the different procedures, and effectively accessing protection. And that's why they're assessed negatively. Since 2023, there's also a new procedure in Czechia to determine statelessness under the authority of the Ministry of the Interior, but it only initially leads to tolerated stay, and some rights have been secured through the law, but they're still quite limited. And we have had some more developments over the last few years, with Albania introducing the bylaws on its SDP as well, which is currently developing its implementation. And there has a lot more information on the briefing about how the different SDPs have been implemented in practice. In red, you can see all the countries that in the index that don't have an SDP, but most of them have a mechanism through which stateless people may be able to have their statelessness determined, for example, through residence permits or applications, immigration applications in asylum context. But the purpose of these procedures is not to determine statelessness, and that results in significant gaps. And the little tiny blue dots that you see are our glimmers of hope, where we have seen some discussions or political commitments to introduce an SDP. And you'll be hearing from our colleagues in a bit about some of these countries as well. So looking back at the briefing, what the briefing essentially does is examine each core element of an SDP in detail, and it analyzes how the countries in the index have established the SCPs and how they're performing against the best the best practice. There's no time for me to go into detail into each of these sections, so I do invite you to read the briefing, but I will only highlight some areas. The first one I want to highlight is access to procedures, which is one of the areas where there's actually good practice from several countries, as most countries that don't impose time limits on accessing the SDP, no fees. People don't need to already be lawfully residing in the country in order to apply for the SDP. And several countries provide some flexibility and accessible ways to apply for the SDP, including having, for example, applications in several languages and not requiring specific documentation. But there are still gaps across several countries, particularly with regards to coordination between authorities and public information about the SDPs. Routes to naturalization is actually the theme that is assessed most negatively in the index, and all of the index countries fail to properly exempt stateless people from obligations that it's difficult for them to fulfill, and that creates a disproportionate barrier for stateless people to acquire nationality. And finally, to zoom in on statelessness status, and so to give you also an example of how this area is assessed across the briefing itself, there's quite a lot of mixed practice on this theme. And how we outline it in the briefing is that we essentially establish what's the best recommended practice on this particular area. So including, for example, having automatic permission to stay with a renewable residence permit of minimum 2 years, preferably 5, and access to several rights, including work, education, family reunion, social security, etc. Then we give you an overview of practice, including best practice in Armenia, Moldova, and Spain that give a permanent right to reside for stateless people and a number of economic and social rights. And then we give you a specific country example, which for this particular theme is from Spain, that grants an automatic permission for people to stay and all of the rights that the 1954 Convention requires. And then finally, the briefing also presents key action areas for states, and that should include, in our perspective, first of all, introducing fair and accessible SDPs in line with norms and good practices. And then secondly, ensuring that those SDPs are leading to effective protection, as I've already mentioned as well. Thirdly, there should be specialized training and cooperation between authorities who may encounter stateless people, and also cross-referral mechanisms between asylum, detention, and SDPs. And fourthly, there should be accessible routes to naturalization. So states should have these in place, for example, by expediting naturalization procedures for stateless people and exempting them from requirements that they're not able to fulfill, such as citizenship or integration tests, language tests, application fees, etc. So do read our briefing for more information, and I'll hand back. And for now, I will stop sharing my screen so you can hear a bit more from our experts at national level as well. And for this, I'm going to invite Leonor Felix da Costa and to turn on your camera, as well as Denis Nezelovsky, if you can also join us, who are our index country experts in Portugal and Germany. And you'll also have the chance to hear in a bit from our colleague in Austria who couldn't join us live. But so first of all, thank you for being here. And Leonor is working for JRS Portugal. Dennis is working for State Free in Germany. And I'm going to ask you both the same question, which is essentially if you could give me an overview of what recent progress has been made towards introducing an SDP in your country, and why do you think this is important? Leonor, do you want to introduce this first?
Sure. Hi, good morning. Thank you for the invitation. My name is Leonor, and as Patricia said, I work for JRS Portugal as a legal and advocacy coordinator. Over the past couple of years, Portugal has finally started to make some real progress towards introducing an SDP, a statelessness determination procedure, although the journey has been a bit slow. So in 2023, a new law entered into force, formally recognizing the status of statelessness in Portugal. And this was a very important first step, and it was largely driven by the advocacy efforts of one political party in particular, Partido Livre, which has really taken the lead on this issue. Until then, Portugal essentially had no specific legal framework addressing statelessness. So the adoption of this law in 2023 already represented a small but significant light being switched on. However, and this sometimes happens, unfortunately, while the law recognizes status, it postponed the creation of the actual procedure to determine who is stateless in Portugal. In other words, Portugal acknowledged the problem, but did not yet create the practical mechanism to recognize it. And for almost 2 years, this issue remained somewhat forgotten. And it was only last year, in December 2025, that the topic returned to the political agenda, when 4 political parties presented 4 different proposals to regulate the SDP. This renewed political attention is very encouraging and suggests that there is now broader consensus on the need to move forward. So establishing an SDP is crucial for many reasons, but one of them being that several Portuguese laws already refer to the stateless persons and even provide for more favorable treatment, for example, in nationality law. But in practice, these provisions are almost impossible to access without a formal procedure to recognize who is stateless. At the moment, the only realistic way someone can benefit from this more favorable treatment in Portugal is if they have already been recognized as stateless in another country and then moved to Portugal. Um, as a result, Portugal reports very few cases of statelessness, yet we know this does not reflect reality. Stateless persons do live in the country, but they remain largely invisible in legal and administrative terms. So, to conclude, the introduction of an effective SDP is not just a technical legal reform, it is a necessary step to ensure that existing rights can actually be exercised and that stateless persons in Portugal can finally be identified, protected, and included.
Thank you so much, Leonora. That's a
Thank
really good overview, and we'll have a chance to hopefully hear a bit more in a second as well in terms of how that's been developing in Portugal, because we're quite keen to follow that progress as well. And now, Dennis, back to you. What's happening in Germany?
Question. And I think what I liked about your presentation just now was also that the first step is the legal framework. And when we talk about Germany, I think besides the conventions, there is basically none. And so we are very optimistic about a specific draft law, which in Germany, draft laws always have very long and complicated names, but it's basically to further develop and digitalize the immigration administration. And so we see it as an opportunity to also improve identification and recognition of statelessness. Because until now, there is quantitative data, but no qualitative information on statelessness in Germany. And this information is also very needed in order to, say that the quantitative data is also reliable and actually correct. And so Germany, as a country that is very proud of its registers, has the unique situation where there is actually no entry field for statelessness, except when it comes to categorizing a person as stateless. So it's basically a demographic, a statistical demographic, but there's nothing linking it to any qualitative information, and so also not to a specific status or rights. And so we see this, of course, as a huge hurdle, but at the same time, this draft law aims to improve coordination between authorities, increase transparency, and also strengthen data quality and security. And so we see it as a possibility to also improve identification and recognition procedures in Germany that are happening kind of everywhere. And yes, I think among different also authorities that are involved. And so we see it as also as a possibility to, for the first time, have qualitative information on statelessness and on claims that are presented, on proof that is presented during a procedure, and also how it is evaluated by an authority. And for the first time, there will also be the possibility to actually collect information on decisions and also motivations of like why was proof, what proof was verified, what was deemed to be authentic and verifiable, and so also why was a person recognized as stateless. So we have multiple effects that we are seeing as potentially coming out of this draft law when it will be implemented. Our recommendations were all transposed in this draft law, and it will, of course, be also a first step in the direction of having a legal framework where authorities will be able to have more legal security when reaching a decision, because they will see in a file, for example, when another authority has already made a decision on determination of statelessness, on why they did it and how they did it. And so we expect more uniformity in decision-making processes, and also then more and like higher quality data in relation to statelessness. And yes, so this is something that we're very happy about, that right now our recommendations are in this draft law, and we're positive that this will remain like this. And of course, this will then, I think, make also the case for introducing even more legal frameworks in Germany to enable then better identification procedures, and also the bridging the gap from identifying statelessness to leading the person being able to access the specific rights that they are entitled to.
Thank you, Dennis, and thanks for highlighting the need to lead to that protection, and also the hope that this will all lead to more coordination between authorities, which is exactly one of the points that I had made, is still needs significant improvement across Europe. I now want to ask the same question to our colleague Leonard, who couldn't join us live, but he was kind enough to send us a pre-recorded intervention exactly responding to this question as well. So hopefully my colleagues in the background will make some magic and bring Leonard to life.
Hello, everyone. My name is Leonhard Karl-Blasnik. I am an independent human rights consultant based in Austria and individual member of ENS. Thank you for the invitation to speak at this webinar, and sorry for not being able to be here live. In 2008, Austria ratified the 1954 Convention relating to the status of stateless persons. Since then, only very few convention rights have been incorporated into domestic legislation, and there is no statelessness determination procedure in place until today. This causes huge protection gaps. At the moment, stateless people living in Austria can only access other routes to regularize their stay. If they do not qualify for those routes, they may find themselves in situations of legal limbo, like the so-called tolerated stay or Duldung. During the last 18 years, we have seen no changes to that, while the number of people living in Austria who are at risk of being stateless has grown constantly, although it's still very small compared to Austria's 9.2 million inhabitants. As of today, the Central Register of Residents lists 5,100 stateless people, 16,500 persons under the label of nationality undetermined, and 700 persons under the label of nationality unknown. Since there is no definition of a stateless person in domestic law and authorities are lacking guidance, these statistics are far from being reliable. What can be said with certainty, though, is that children are affected in particular, since 75% of all people mentioned before are under the age of 18 and were born in Austria. Due to the lack of an SDP, every single authority on the federal, regional, and communal level currently has the duty to examine a person's potential statelessness independently. It does not come with surprise, then, that oftentimes one person is registered as stateless by Authority A, while Authority B holds the person to be of undetermined and Authority C of unknown nationality. During the last years, a small coalition of people and organizations like the National UNHCR Office, Austrian NGO SOS Mitmensch, and myself, with the help of ENS, tried to raise awareness, gather and provide information on the rights and the situation of stateless people living in Austria, and convince decision makers to introduce legal and practical improvements. Since 2019, Austria participates at ENS Statelessness Index, and since then, I'm holding training courses and seminars on the issue. All these activities might have inspired the first more or less concrete political commitment towards introducing an SDP in Austria. This commitment first appeared in the current federal government's 5-year policy program, and it was further outlined in the legislative proposal regarding the implementation of the EU Pact on Migration and Asylum, which has been submitted to Parliament this January. Like in many other European countries, the current political framework in Austria is far from being protection-oriented. But I'm more confident than ever that decision makers could have the courage and follow their commitment and introduce a proper SDP leading to a residence permit once they realize that this will not only change the world for a very small group of stateless people living in Austria, but also make things tremendously easier for all Austrian authorities involved. Many thanks again for the invitation. Bon courage to everyone and best wishes from Austria. Goodbye.
I want to say thank you, Leonard, for sending this. And just to highlight as well something that Leonard mentioned in his intervention, which is although childhood statelessness is not the focus of the webinar today, we do have a dedicated section on preventing and reducing statelessness in the index as well. And I really like how Leonard made this connection between the need for SDPs in order to reduce the stateless population in the country, grant them protection, and prevent statelessness from arising in the future as well within the country. So now back to our live panelists. Dennis, I would like to also understand, I know that State Free has been playing an important role in advocating for the introduction of an SDP in Germany. And so can you tell us a bit more about your approach and what you have achieved so far as well?
I think the first point for us is that there is a common interest with the Interior Ministry, but also with members of parliament, but also local authorities that are all kind of involved in dealing with statelessness and creating sustainable solutions. So in this regard, I think the common ground is that in Germany, as in Austria and in other countries, there are a lot of people with undetermined citizenship and very few recognized people or registered as stateless because they're not really recognized. They don't have any access to rights in this statistical category. And there might be even far more people that are affected by statelessness, and so are it is very, very relevant to resolve their status and also situation, not only for us but also for the government. And I think that this law that I just talked about is one point of entry where we actually had a very easy entry because it is, of course, not an SDP, but when there's a lack of clear qualitative data and they want, of course, everybody wants data to be reliable, well, and there is none for statelessness, then it's very easy for us to say that, yes, basically, this is a gap that we need to fill, and actually this will help also beyond that and will help also hopefully in practice when it comes to recognizing statelessness. And so this is one first step, I think, identifying also the fields in which the government itself is already active. But at State Free, we also follow an approach where we do not rely only on solutions that are coming directly from the government. We're not always waiting for the government to first be very active. We're also trying to push forward our own solutions that we are trying to design together with the government, but also with people with lived experience and experts in this field. And so one of these projects is, for example, the case assistant. Basically, we're trying to develop like an SDP on another level where it is basically accessible for everyone. And so what we do is we enable with software that people can structure any claims and evidence of statelessness that they have. Because nowadays in Germany, people pay a lot of money for lawyers that are then not trained on statelessness to present their claims to authorities. And often they lack the expertise that the people themselves have already, but also the claims that they present lack quality and also information. And so our form is designed to enable people to provide high quality claims of statelessness that are structured in a way also that the authority can work with and in the best way, basically also for them to assess then all the information. And so in this regard, we work together with our community members, but also with the authorities to make sure that basically what comes out, so what is in the tool represents what the community wants and needs, and also that what comes out of this tool will be something that the authorities want to work with and can work with quite easily. And so for that, we did our research, which we published in articles, also our findings. And this is one side of this SDP is basically what, right, we want to enable people to apply for the recognition of statelessness. And the other part is the evaluation process itself. So we have another software that we're developing for the authorities, which is called RuleMap, which will then be a tool that guides authorities through the process of evaluating evidence and information in order to reach a decision. Because also right now, authorities do not know basically what steps there are to recognize statelessness. And sometimes what statelessness is and where they can find important information. So right now, as there's no basically legal framework, but also no guidance or anything, this is a huge challenge for Germany, and often the right hand doesn't know what the left hand does, and so with regards to the Interior Ministry, when we talk of kind of the head, this creates also sort of a headache. And so right now, for us, it is very important to involve all the different levels of the government together with the people with lived experience to design tools that we want to see in practice. And this would, if it is successful, and we hope for it to be successful, it will then just only create a larger argument for implementing an SDP and having solutions that are kind of adopted at the political level as well that will work for all Germany.
Thank you so much, Dennis. Really exciting overview of what a ground-up project can look like, and also very practical tools that authorities can use. And if you haven't seen it yet, there are links to some of the resources that Dennis has mentioned are on the chat. And now I'll hand back to Leonor as well, because we're also keen to understand about the work that JRS Portugal has been doing to advocate for an SDP.
Yes. So thank you, Patricia. Our organization has played an active role in advocating for the introduction of an SDP in Portugal, mainly through legal advocacy, evidence gathering, and direct engagement with decision makers. So at JRS Portugal, we prepared a legal opinion analyzing those 4 different SDP proposals I told you about that had been presented by 4 political parties. So this meant going article by article, comparing approaches, identifying good practice that are in line with international standards, and also being very clear about what could create new risks or barriers for stateless persons in Portugal. At this stage, I felt it was essential to first understand what the reality actually looked like in Portugal. So the first step was quite simple. I spoke with my colleagues at JRS Portugal and reviewed our internal database to see whether throughout all our years of work, we had ever formally accompanied a stateless person. And officially, the answer was no. Now, I'm quite sure that this does not mean stateless persons do not exist within the populations we support since 1992. Rather, it shows how invisible statelessness still is. In practice, people are often labeled simply as undocumented or in an irregular situation. I then reached out to other organizations working with migrants and refugees across the country, but the feedback was very similar. Reported cases were extremely low, most of the times even non-existent. When I looked at official data from public authorities, the situation was even more striking. According to figures from 2023, Portugal had only 12 recognized stateless persons. Of course, this number is not a reflection of reality, it is a reflection of the absence of a procedure. So this became the first key part of the legal opinion I drafted, not only to explain what statelessness is, but also to demonstrate how it manifests, or rather fails to appear in the Portuguese context. The second part focused on analyzing the legislative proposals themselves. I examined them, or all the articles, assessing them both in light of international standards, with the very valuable support of Patricia here, so thank you for that, and in terms of how realistic and workable they would be within the Portuguese system itself. Now, JRS is in a somewhat unique position in Portugal. We have a long-standing experience supporting migrants, refugees, asylum seekers, and people in irregular situation across different stages of their integration process. Our work ranges from legal support and documentation issues to access to employment, education, healthcare, and so on. So this holistic experience, combined with a strong legal and advocacy team, allows us not only to support individual cases, but also to understand how the system functions and sometimes how it fails to function. For example, one political party proposed applying a specific and already existing residence permit for persons recognized as stateless. And we were able to draw from our practical experience and explain that this type of permits that already exist has not worked effectively ever in practice. So this measure would not necessarily translate into real protection if that proposal moves forward. I don't know if anyone at this webinar is from Portugal, but basically that proposal intended to provide a residence permit under Article 123 of the Foreigners Law to the persons with a recognized stateless status. In that sense, our legal opinion was grounded very much in field experience. Even though we had not formally identified stateless persons in our case law, our broader experience with legal barriers, documentation gaps, and administrative practice allowed us to provide concrete, realistic recommendations. We then submitted said legal opinion to the Portuguese Parliament to be yet discussed during the specialized phase of the legislative process. And for us, this was a very important achievement. It meant that civil society perspectives, informed by daily realities, could directly contribute to shaping the future SDP. And ultimately, I think this is what advocacy in this field is about, not only improving the laws on paper, but making sure that they actually work for the people they are meant to protect. Thank you.
Thank you so much, Leonor. A really helpful initiative as well coming from the European Parliament, but then this civil society push does help improve the procedure, and we're very much all eyes on Portugal to see how this develops as well. I will give the floor back to Alexandra in a minute, but just before we wrap up, I'm just going to answer the question that has been asked on the chat quite quickly, although we are running out of time. But we are of course conducting advocacy to remove reservations in the 1954 Convention. Apologies. And to generally also improve the identity and travel documents that are granted to stateless people in practice, regardless of the international obligations as well. We are working with our partners, JRS Romania, who's our index country expert in Romania as well, to address that, as well as in several other European countries. And I might invite Dennis to answer that question in writing as well, if you have anything to add about the specific work that you're doing in Germany on that. Thank you so much to Leonor, Dennis, and Leonard as well for joining us in this panel. And I'll hand back to Alexandra now.
Thank you very much, Patricia. And thank you again also, Leonard, Dennis, and Leonard for the really insightful discussion and information that you have shared with us. Just before I give the floor to the next panelists, something that stands out to me from this conversation is that progress is possible and it's also already happening, but it often depends not only on the legal framework, but also on the sustained advocacy, especially the advocacy that is led by stateless communities and civil society, such as the one presented by Dennis with the example of the case assistant. And progress also depends on the collaboration with diverse stakeholders, including also authorities or decision makers. And I would say also patience and persistence over time, which at the same time requires also resources in order to conduct that advocacy. Just another reflection, and from a more human perspective, what is also important to recognize is that behind every procedure or reform that we discuss, even if these are marked as green in the map that Patricia has shared with us at the beginning of the presentation, there are individuals that are still navigating very complex and often also uncertain situations. And there are also individuals that are still excluded from accessing these procedures. So as seen from the examples shared in Austria and Portugal and Germany, a legal framework is not enough, and how it is implemented in practice is key. So improving identification and protection is not just only about the systems working better, it's about them being really inclusive and more accessible and more responsive to the realities of stateless people, so that they are fully seen and recognized and able to move forwards in accessing the rights that correspond to them. And with that, thank you again to all the speakers of this first panel. And I'm now very pleased to introduce Nina Murray, ENS Head of Policy and Advocacy, who will be moderating our second panel, focusing on regional opportunities and risks at the pan-European level. Nina, over to you.
Thank you, Alexandra. Good morning, afternoon, evening, everyone. Thank you for joining us today for this really important discussion. I'm Nina Murray, Head of Policy and Advocacy at the ENS Secretariat, and I'm delighted to moderate this next panel, which will explore opportunities and risks at the pan-European level, at the regional level, in terms of identifying statelessness and access to protection for stateless people. Over the past few years, this has been a really key area of focus for ENS's advocacy, including a particular focus on protecting the rights of stateless people through the EU Pact on Migration and Asylum. When the original pact proposals were first published back in 2020, statelessness was largely invisible from the text. And together with our members and partners, we worked hard over the years to engage the Commission, the European Parliament, the Council through the negotiations, pushing for critical amendments that would help to ensure the rights and needs of stateless people were not overlooked. And thanks to these concerted efforts, the adopted instruments explicitly now include the definition of a stateless person. They introduce a legal obligation on all EU member states to identify indications of statelessness during the screening process. And importantly, there are also references to strengthening protection and rights of stateless people and a clear requirement to register claims of statelessness pending a determination through the Asylum Procedures Regulation. So these are all really significant steps forward in recognizing and addressing statelessness at the EU level in EU law. But our work, of course, is far from finished. We're now focused on supporting and monitoring the implementation of these new provisions, which should come into effect very soon in June this year. This includes close collaboration with key stakeholders like the Commission, EU agencies such as the Fundamental Rights Agency, who we're delighted to have with us today, as well as the EU Asylum Agency, and others, including UNHCR, also here with us today, national authorities and NGO allies to really mainstream statelessness in relevant guidance, in training, in tools that will support that effective implementation on the ground. While these changes, of course, represent progress, as we've said, and for stateless people, there are still gaps and challenges that remain, and particularly on access to statelessness determination procedures and durable solutions, as well as critical safeguards to prevent arbitrary detention and removal, return in a Europe that is ever more hostile towards migration. So today we'll be hearing from our expert panel to discuss these challenges and explore both the opportunities for strengthening protection routes and ensuring that the promise of pact provisions on statelessness translate into real improvements on the ground in the EU and beyond the EU. So I'm delighted now, without further ado, to introduce our distinguished speakers. We have Tamas Molnar with us, Senior Protection Officer at the EU Fundamental Rights Agency. Welcome, Tamas. And we also have Christine Goye with us, who's Senior Protection and Solutions Coordinator at UNHCR's Regional Bureau for Europe. And both Tamas and Christine bring a wealth of expertise and insider insight to our discussion today. So I really look forward to their perspectives and how we can continue to thinking about how we can continue to drive positive change in this area. So with that introduction, let's begin with our first question. How can the EU Pact on Migration and Asylum leverage the introduction of more SDPs and strengthen routes to protection for stateless refugees and migrants in Europe? So I'm going to turn to Tamas first, and then we'll come to Christine afterwards. Thanks, Tamas.
Thanks a lot there, Nina. Good morning, afternoon, evening, everyone. Hello, everyone, for short. So my first, let's say, thought in this regard is to recall the new statelessness-related provisions in the pact instruments, mainly in the screening regulation and also in the asylum border and in the asylum procedure regulation. And I would like to zoom in on the asylum procedure regulation, which in the recitals, as Nina has already pointed out, recalls member states' obligations in the field of statelessness and also their, let's say, obligation to identify stateless persons in the context of the asylum procedure at the borders. But also the APR, if I can use this acronym for this regulation, goes further And there's a provision, Nina has already alluded to that, which is more operative, and this provides for the consequence of the identification of statelessness, stating that whereas an individual claims not to have a nationality, that fact must be clearly registered pending the determination of whether the individual is stateless. So we have this timid reference, and this is the closest as it gets to require member states to set up national SDPs, at least as far as EU law is concerned. So here there's this reference, but it doesn't go the full circle yet. It's like the suspended step of the stork, borrowing the title of a great movie directed by Theo Angelopoulos, when one leg of the stork is here on the ground, but the other is in the air halfway towards crossing a line, but not on the other side of the line where stateless determination procedures would become mandatory. So it's like an in-between situation. But it's another push for member states to cross this line and implement in good faith the obligations that have already been assumed under the 54 Statelessness Convention. And Patricia in the beginning also recalled that there's an implied obligation in the 54 Convention to identify one's statelessness. So summing it up, once an individual is flagged as stateless, as potentially stateless, then member states will need clear procedures to act upon, to assess and to resolve their status. So I believe it creates a strong incentive to establish dedicated SDPs, ensuring that identification then goes the full circle and leads to a durable legal outcome. And if I have 30 seconds, also I would like to reflect a little bit on how to address the current gaps. I mean, we have the black letter law that we have, let's say, recalled. That currently the European Commission, as the guardian of the treaties, is currently working on various non-legally binding guidance documents to make the application of various pact instruments smooth and seamlessly connected. And these guidance instruments concerned, first and foremost, the screening process or screening regulation, the asylum border procedure, as well as the return border procedure. So there will be these kind of guidance documents, which should also give more detailed guidance on the operationalization of the statelessness-related provisions of the pact. Some elements are here and there, but there's room for improvement, definitely. And maybe the last thing is what my agency, the EU Fundamental Rights Agency, has been doing. We have elaborated a common monitoring methodology for the future independent national monitoring bodies under the pact. You may recall that in the context of screening and the asylum border procedure, member states must have in place national independent monitoring bodies to assess the fundamental rights compliance of these procedural steps at the borders. So to make sure that there's convergence in the EU across the 27 member states, we have elaborated a manual, a common monitoring guidance, which also gives guidance for future monitors on how to monitor and what to monitor in relation to statelessness in that specific context. So yeah, all in all, we believe that this can help move from paper compliance to consistent and converging national practices after June this year, when the pact starts applying, including the further, let's say, blossoming of stateless determination procedures at the national level. Over to you, Nina.
Thank you, Tamas. Thank you very much for so clearly setting out the content of the pact in more detail. And I always love your stork analogy as representing it. It helps us remember that we're sort of halfway there, but there's still some work to do, and identification on its own is not enough. We need to also see determination and access to protection. So, and also thank you for flagging some of those key kind of guidance documents and tools, such as the monitoring tools that will support implementation. Christine, over to you to respond on that first question. Thank you.
Thanks, Nina, and thank you to the ENS for organizing the webinar and for having UNHCR invited. So some mentions were already made of the important statelessness provisions that we find in the EU Pact, and if indeed effectively implemented, they can really strengthen the identification and protection of stateless people in the EU. This is, of course, intended to ensure protection and access to protection for stateless people. Tamas mentioned the references in the screening regulation and also the requirement in the asylum procedure regulation to register any claims of stateless pending determination. We believe that the latter one provides an important entry point towards the establishment of procedures to determine statelessness. There has been important advocacy work done by a lot of organizations, including, of course, the ENS, who has worked hard to have the inclusion of statelessness consideration in the EU Pact on Migration and Asylum, and has published different notes, including a briefing note with analysis and recommendation for implementation. As you said, there are some progress to be noted, but not fully. And we have also tried to continue the advocacy work, and we have, as UNHCR, outlined and highlighted the importance of the stateless related provision in our advocacy messages on statelessness and the EU Pact, which we can share in the chat for those that are interested. As UNHCR, we continue our engagement with the European Commission and other EU institutions to promote effective implementation of the EU Pact, including the statelessness related provisions. I'll give some examples, maybe just for information also on the different work streams and avenues that have been pursued. UNHCR had the opportunity to present on statelessness and the EU Pact in the third Asylum Procedure Regulation Contact Committee meeting back in June 2025. One of the very few opportunities to highlight to member states how to implement the statelessness related provisions. We also participated as a panelist in the European Migration Network platform on statelessness, multi-stakeholders meeting on statelessness in the EU Pact in October 2025, alongside FRA and the ENS. And we have noted with some satisfaction that following this event, the European Commission has drafted statelessness guidance for member states. And we continue to engage with EUA and Frontex to ensure statelessness is reflected in relevant guidance documents and tools. We have very good collaboration, and we welcome the work done by EUA and Frontex, including on the EU Pact screening toolbox, the EUA practical guideline on nationality, and training manuals on statelessness. So in addition to these advocacy efforts to continue to make progress, we also see through our country offices in different countries in Europe that there's a lot of work being done to support the Pact implementation indeed. And I'll just give a few examples, and I noted some participants might come from these countries, but in Bulgaria we supported the provision of detailed observations on implementing statelessness related provision in the EU Pact. In Romania, there's been advocacy for identifying statelessness person during screening procedures as part of legislative reforms. And in Italy, our UNHCR colleagues assisted authorities in developing screening forms with indications of statelessness. So these are just a few examples of the work that is being done. We continue, of course, the advocacy work, but we're really entering a more practical implementation phase of the Pact as of June, and a lot of changes are being made in national legislation to incorporate those changes. And we see those as also good avenues to progress on the SDPs and other statelessness related provisions. Thank you, Nina.
Thank you very much, Christine, and that was really helpful to hear more about UNHCR's engagement in both at regional and national levels on the implementation of the Pact, and also this this important the view that we all share that the introduction of the provisions are an important opportunity to leverage more SDPs at national level, and particularly that key provision in the APR. And also it's great to hear more about this multi-stakeholder approach, which we agree is really important to implementation now. So ensuring that statelessness expertise reaches those key agencies and institutions that are going to be responsible for implementing the pact, and that officials on the ground can have access to that expertise as well in the form of guidance and tools and training, which is really important, of course, to secure that implementation and to monitor that implementation. So with that, we'll move on to the second question. So next question is, what are the main opportunities and also risks at regional level currently to improve the identification and protection of stateless people, sort of beyond the pact, if you like, as well as in the context of the pact that we've been focusing on so far? So I'll hand first this time to you, Christine, to answer that second question.
Sure, thank you very much. So indeed, there are risks. I'll start with the risks, maybe to say that statelessness competes with other priorities in the EU Pact and may therefore be overshadowed by other pressing issues. It's true there's a big conversation around migration issues in Europe, and it's sometimes difficult to make the point that it's not only about this, including about asylum. And as I think you noted earlier in the remarks, there is indeed a shrinking protection space in Europe, with increasing restrictive asylum and nationality laws in practice across the continent that could undermine the identification and protection of stateless people. It is therefore quite important to underscore that it is important to closely monitor ongoing developments and using every advocacy opportunity at our disposal. On the opportunity side, we just highlight a few. There is a strong momentum in our view to strengthen the protection of stateless children in Europe through ongoing work also with the OSCE and the Council of Europe. It is indeed a bit broader than the EU conversation, but I think it's quite important to mention that ongoing work, it's not directly linked to the identification of stateless persons within asylum procedures, but I think it contributes to having important conversations around statelessness. And I wanted to flag the ongoing work of the Council of Europe Committee on Legal Cooperation to revise the Council of Europe Committee of Ministers' recommendations. So it's a bit of a mouthful on access to nationality for stateless children. We believe this represents an important opportunity to advance the identification and protection of stateless persons more broadly. There have also been some recent publication of 2 regional reports showcasing good practices in addressing childhood statelessness. One joint OSCE UNHCR compilation of good practices on the prevention of childhood statelessness, and the Council of Europe compendium of promising practices on access to nationality for stateless children of 2026, which provides further opportunity to build on this work. Just wanted also to mention that another opportunity coming together with the Council of Europe, OSCE and ENS, UNHCR aims to organize a dedicated expert roundtable on addressing childhood statelessness towards the end of the year, to provide also states with an opportunity to exchange good practices and identify concrete steps to close existing gaps. I wanted also to mention that it is important to enhance the protection of stateless persons, including through the support for the establishment of SDPs and the strengthening of existing ones. And this remains a priority for UNHCR. We have noted some positive signals in several European countries, some of which date back from the 2023 regional SDP consultations organized by UNHCR in Madrid. And also here, if I may just put a bit of light on a few countries, one being prominently featured today, which is Portugal. UNHCR is actively also working with different political actors to develop a draft, and we are working jointly with JRS also and others as it was presented earlier. North Macedonia, there's also a strong political will to establish an SDP with good collaboration with UNHCR and the authorities on this respect. In Malta, the government has recently re-expressed the will to establish an SDP. So we're exploring some options for peer-to-peer exchanges with Italian authorities. And indeed, in Italy, in Ireland, excuse me, there have been the country has made pledges to set up a procedure while waiting for the European Commission guidance. So there's just a few examples, obviously not exhaustive, of opportunities that might exist broader than the EU Pact, but could maybe channel some of these important conversations and make progress across the board, and indeed to maybe also push for more SDPs and their implementation. Back to you, Nina.
Great. Thank you, Christine. That was a really comprehensive answer covering different elements, in particular drawing attention, which is really welcome, to the work around childhood statelessness that is ongoing currently, and lots of useful publications and initiatives on that front at the moment. And good to hear, of course, that introducing and strengthening SDPs is a key priority for UNHCR, as it is for ENS and our members, and using and leveraging the opportunity of the Pact and every advocacy opportunity, as you say, that we can to progress those shared goals. Tamas, we have a few minutes left to hear from you in answer to that question, so please go ahead.
Thanks, Tina. I'll try to do the impossible, in 3 minutes, saying any meaningful. So I would like to zoom in on one instrument which is currently being negotiated in the EU when looking for some risks beyond the pact context. And this instrument, I think, is the well-known, famous or infamous proposal for a new return regulation, which will replace the Return Directive, which is the key EU-level instrument setting out common rules and procedures on how to return those people who don't have the right to stay within the EU. So I would like to highlight 4 points really telegraphically from this proposal which raise issues. The first is the lack of reference to statelessness as such, or member states' international obligations under international law governing statelessness, like the 54 Convention. So it's like a mismatch vis-a-vis, for instance, the pact instruments, the screening, asylum procedure regulation, but also the Frontex regulation, which all have a reference to statelessness or recall member states' legal obligations in this regard. Back in the past, when there was the 1.0, revamping exercise, when the Commission proposed in 2018 a recast for the Return Directive, the Fundamental Rights Agency issued a legal opinion, listing all the problems from the fundamental rights perspective. And already back then, we suggested to the co-legislators to include a reference to statelessness and the 54 Convention. That this has gone unnoticed, and even in the new proposal, in this 2025 return regulation proposal, there's no reference to statelessness, which is a bit striking. It's inconsistent, and just it also risks, rendering stateless people who are by default invisible to be, or to continue to be invisible. Second, which is related, this is the failure to include obligations to identify statelessness. We've already seen in the pact context, both the screening regulation and the asylum procedure regulation contain such a reference. So this asymmetry is again quite striking. Why it's not in the return regulation proposal? And I just skimmed through the version adopted by the LIBE committee of the European Parliament, which will be voted in plenary this week. And there's no reference to statelessness identification either. There's no reference to the definition of a stateless person, again, which can be found in other pieces of EU legislation. So this inconsistency is quite striking. The third point is this new obligation to cooperate for returnees, and all the concerns regarding the implementation of this obligation to cooperate when it comes to stateless people. It means, people returnees will be, obliged to hand over their identity documents, travel documents, or to provide information regarding nationality, and so on and so forth. But statelessness is a situation when individuals often lack such documentation for reasons beyond their control. So, there's a risk of sanctioning those who are just unable to provide those documents, and then they will fail to fulfill this obligation to cooperate. And at national level, where similar rules already exist, then there's evidence that stateless people are sometimes wrongly assessed as being non-cooperative when their nationality cannot be determined. Evidence points us to Poland, for instance. And the fourth and last point in this regard is the risk for arbitrary and prolonged detention, since the proposal takes away an important safeguard which is in the current return directive adopted in 2008. This is to end detention and pre-removal detention when there's no reasonable prospect of removal. So this is a key safeguard, and there's this reference is no longer there, which heightens the risk of prolonged detention of stateless people. Yeah, there's even EU Court of Justice case law to end detention when there's no longer reasonable prospect of removal. The same obligation stems from the Strasbourg Court's case law. The UN Human Rights Committee has also explicitly said that in its General Comment 35. So this is another key shortcoming. And just to finish off on some positives, I mean, what are the opportunities? I mean, you, ENS, and all the members of ENS and all the listeners here, I mean, you are a great opportunity to let's say, push all the small entry points we've identified so far further, and a concerted push can make a miracle. So I fully believe in the power of this community and to make a change in all these tiny things that are, let's say, dispersed across, but taken together with the great push from the community can make a quality change. And the last point, there will be some anniversaries. This year, this is the 65th anniversary of the 61 Convention on the reduction of statelessness. Then this year is the 20th anniversary of the Council of Europe Convention on the avoidance of statelessness in the context of state succession. And next year is the 30th anniversary of the European Convention on Nationality. So sometimes symbolism matters. And sometimes, you know, political decision makers can have a moment of grace when there's some symbolic moment. So this is also something to consider for the future. Over to you, Nina.
Thank you so much, Tamás, and thank you for so clearly and articulately as ever outlining some of those really key concerns that we absolutely share about the return regulation proposal, and particularly around this invisibility of statelessness, which indeed is frustrating after all the work that's gone into the pact and introducing you know, those provisions in the pact. It's disappointing and particularly concerning to you know, that we don't see an acknowledgement of the rights and protections that should be afforded to stateless people in the return regulation. And we've been indeed working where we can with allies in Brussels and across Europe to try to challenge some of those shortcomings. We don't have time to go into that in detail now, but thank you for laying that out. And I see some more information being shared by colleagues in the chat if you're interested to find out more. Also, please don't hesitate to get in touch, anyone, on these topics. So I do want to leave time for Alexandra's final reflections. So just a huge thank you to both of you for taking the time, for being here and sharing your reflections. We've covered a lot in that short time. I really liked your positive ending there, Tamás. You know, push from the community can make change happen, and we firmly believe that. And without further ado, Alexandra, back to you. Thank you very much.
Thank you very much, Nina, and big thanks again to Tamás, to Christine, and to all of our panelists for sharing your insights, for sharing your expertise and reflections, and most importantly, for your commitments to addressing and still working on this issue. I would say in the few minutes that I have left that, as we have heard across both panels, there is a growing recognition of the need to improve how stateless people are identified and protected in Europe. But recognition alone is not enough. There are still significant gaps between policy and practice. There are significant shortcomings and inconsistencies, as Tamás was just mentioning, and too many people continue to find themselves in situations where they are effectively unprotected within legal systems that can seem good on paper, but ignore the reality of statelessness. And what today's discussions have highlighted is that solutions exist. already, whether at national level through dedicated procedures or advocacy, or at regional level through frameworks like the EU Pact and its statelessness-related provisions. But these solutions require political will, they require coordination, they require continued commitments to center the realities of those impacted by statelessness. As mentioned at the beginning, statelessness is not just about the legal status, it is about the access to rights, it's about dignity, and it's about ensuring that people have a sense of belonging. And at ENS, we will continue working together with our members and partners to contribute, to monitor the progress, to push for these changes, to use this window of opportunity with the anniversaries and contribute to the progress, including also through the upcoming collaborative advocacy guidelines, which we are really looking forward to sharing with all of you soon. And before we close, we would really appreciate your feedback on today's session. A short poll will appear on your screens, so please take a minutes to let us know your thoughts. And we also encourage you to explore and share the resources that have been mentioned throughout today's session and that have been shared in the chat, and to stay engaged with this work beyond today's webinar. Thank you very much again to everyone who joined us today and for your interest in this relevant issue. And we wish you a lovely day and see you next time.